The Justice Department implored the Supreme Court to strike down race-based redistricting, as the justices are slated to hear oral arguments in the coming weeks on whether Louisiana's creation of a second black majority district was unconstitutional. The DOJ, in a brief to the High Court, argued that Louisiana's creation of the second black majority district, created to comply with a different court order, was an unconstitutional racial gerrymander. The department also called on the High Court to strike down its 1986 ruling in Thornburg v. Gingles, which set the current parameters for legal challenges of congressional maps under Section 2 of the Voting Rights Act. The High Court will hear re-arguments in Louisiana v. Calais on October 15th, less than 4 months after the justices punted on a decision in the case following an initial round of oral arguments this year. With the second round of arguments, the Supreme Court asked parties to answer whether Louisiana's, quote, intentional creation of a second majority-minority congressional district violates the 14th or 15th Amendments of the Constitution. The case centers on Louisiana's congressional map, which has faced lawsuits since the original map was passed into law earlier this decade. The GOP-dominated legislature originally passed a map that was split 5-1 between Republican and Democratic seats, with the lone Democratic seat being a black majority district in compliance with Section 2. The state was sued for violating Section 2, alleging that the black population was large enough that under the law and the Gingles framework, a second black majority district should be created. After that lawsuit, the state prevailed. The legislature passed a new congressional map that included a second black majority district, creating a 4-2 split map between Republican and Democratic seats. The new map led to another lawsuit from a group of voters who claimed that creating the second black majority district amounted to an unconstitutional gerrymander. The Supreme Court ruling on the case could have sweeping implications for congressional maps in various southern states where Section 2 compliant districts have been created by legislatures or court order under the Gingles precedent.